Okay, so now the issue is, are there tricks here in torts? And we can go through, we see, now, if the call to question says what intentional torts can the plaintiff get, and you start with negligence, you fail. If they give you an intentional tort, try to find as many as you can. And don't forget the concept of transferred intent.
So you'll notice in proponics, if you have that we've organized the intentional torts so that it's really easy for you to memorize that list. There are intentional torts involving the person and intentional torts involving property. And that breaks it up into two chunks so you can easily memorize. Another classic hypothetical is one that's centered around defamation. And that in essence allows the bar to test constitutional law at the same time because of the constitutional overlay involved in defamation. So you need to try to find a matter of public concern in order to raise those constitutional issues. And you need to know the privileges.
Figure too, I guess we could add, right?
Yeah, public figure as well.
So those issues have to be addressed every time they test defamation. And that's something that you need to know.
Everyone that's listening to this knows duty, breach, causation, damages. I guess the main comments would be, don't get to duty and say, oh, no duty, and then write yourself out of the essay. You need to go through all of the elements. And then also these special ones are always 10 to 15 point issues that without which it's very hard to pass. So look for negligence per se, where you're going to have a statute, maybe even other special duties with landowner duties. And then if defenses are at all there, discuss all the colorable ones.
Right. The defenses, you do not have to be able to prove. All you need to do is have a colorable reason for raising them.
Less often we see strict liability, usually ultra hazardous. Vicarious liability, often. Products liability, that's its own separate beast. And that's a racehorse tough hypothetical. Look at all those theories that are listed down there on that slide.
Right. So study the past hypotheticals so that you can know how these things should be addressed.
We haven't seen these issues lately. That doesn't mean they won't come up. We have no way of knowing whether they've sort of gone out of favor or whether they're ripe to appear. Interference with contract, malicious prosecution, and occasionally we see a legal malpractice hypothetical, but not recently. That's a case within a case, because to prevail in a cause of action for legal malpractice, you have to be able to prevail on the underlying cause of action that the representation was about. That's necessary to show damages.
One thing is, if it's remedies, you got to know the specific measure of damages for each tort. So
and that may sound like a huge pain to you, but you really do need to know those, because it's not only can appear in the essays, but it likely will appear in the multiple choice, in the MBE part of the exam.
And then you see damages. And we also, the main issue there, look at punitive damages. The key word to focus on is reprehensibility. You're going to be focusing on factors like physical harm, financial vulnerability. Was this repeated conduct? Was there a reckless disregard? And then there's this due process limit that you probably all remember from remedies class. And then remember, it has to be proportional.
Okay, and again, restitutionary remedies look to the defendant to see if the defendant's been unjustly enriched. The issue of constructive trust comes up about once every 3 years, but I'd know it if I were you.
Junction is like the specific performance in that you should sub-head note every one of these main elements here so that you get this into your book. That's what the grader is going to be looking for.
And then we list a couple of special hypotheticals that you probably ought to go back and take a look at. The first thing you see listed there is the kind of hypothetical that involves fraud and negligence. A lot of times that'll involve property, like a classic fact pattern that involved the sale of, I believe it was a condo. In any case, it had a deck and it had bat droppings, and there was a lot of lying going on and a lot of damage. And so that's an example of that kind of thing. Second kind is the land sales contract and some problem involving the land sales contract.
Yeah, so you need to see how these have been tested in the past. So the best way to success is to study the recommended hypotheticals.